Hi, thank you for tuning into my YouTube channel. This is Jack, the immigration attorney, and today we're going to be talking about traveling after the H-1b petition has been filed by the employer. So now we're in June of 2018, and a lot of people are starting to get their H-1b receipts. Congratulations that they've been selected in a lottery. Now, they have plans to go back to their home country before October 1st, before the H-1b is approved. And a lot of them are on OPT, initial OPT or STEM OPT, and they're worried that they might not be able to make it back. So this video is going to talk about that. Well, first of all, you have to understand that H-1b can be filed in two ways. The first way is called consular processing. That means after the H-1b petition is approved, the applicant employee is not seeking to change status. This employee is going to take the approval notice, the I-797B, without the I-94, and fly back home to their home country to get the H-1b visa stamped in their passport. Now, that is consular processing. So on the form I-129, where the employer petitions the employee for the H-1b, they will specify a consulate or embassy where this consular processing visa stamping, as they call it, will take place. Now, because this is consular processing, the employee is not changing his or her own status. So if this employee is on, say, like STEM OPT or OPT, and their OPT extends beyond October 1st of that year, then that's fine because they could choose to go sometime after their H-1b is approved to get stamping and return to start their H-1b status, and they could do it anytime they want. Now, if the petition is filed for the second way, which is change of status, which means that the employee's status will be changed when the H-1b is approved, and usually that happens after October 1st when H-1b officially starts. H-1b can't really start before October 1st, so therefore the change of status will occur after October 1st. So what happened there is that there's rules in immigration regulations that if you leave the United States in the middle of a change of status application, then that change of status application can no longer occur because there is not a continuation of the previous status to be changed. So let's say that an H-1b employee is on an OPT status, and that OPT status ends in August of this year. And the employee learns that the H-1b has been selected in a lottery, and the employee wants to return home for whatever family emergency or a wedding. Most often that's the case. Then he wants to come back. Then in that situation, I would say if you file a change of status. And I mean, if the employer files a change of status for the I-129, then this person will probably have to wait in the home country until September, and hopefully the petition is approved, and if there's premium processing, the employer is encouraged to use it so that the person can wait in their home country since they're going back so close to October, and then get the visa stamping, return to the United States on H-1b, because H-1b visa can be issued 30 days before October 1st. So generally, the consulate will entertain a visa application before October 1st. So if this person can wait until October to come back, that would be great. If not, let's say this person has to travel in June and is coming back in July, which is fine because this person presumably should have an F1 visa, the I-20 offer letter, and all these good stuff that they need in order to come back on an F1 visa while they are on their OPT. And for a list of those documents, you can easily Google them online or reach out to me. I can provide you with a list of documents that are needed for an OPT F1 entry into the United States. So let's say this person is coming back in July while his visa is still valid and his OPT is not expired yet. So this person comes back successfully on their OPT, on their F1 visa, and resumes their OPT status. Now, when it comes time to the H-1b approval, the USCIS will say, well, you've left the United States, and therefore we cannot change your status from F1 to H-1b because there's that discontinuation of your status. So H-1b has two components. There is the change of status, and there is the merit itself. So meaning, like, should the H-1b petition itself be approved? And the petition itself has to do with specialty occupation, bona fide employee-employee relationship, and the existence of the petitioner and all that stuff. So that part is the petition. So the petition will still be approved if the employee is qualified for H-1B, regardless of the change of status component, which is the second component. Now, the change of status is going to be is not going to be approved because the person had left the United States and come back to the US. So what happens is that because the change of status cannot be approved, then the applicant will get an I-797B approval notice without an I-94 because the change of status is denied. Now, does that mean that the person is out of status? In this case, yes, because, let's say the H-1B is approved on September 29th, and an H-1B starts on October 1st, so the cap gap would only help this person's OPT be extended until October 1st, which means that after October 1st, this person's status completely ends, and it didn't get changed to H-1B, and therefore it stopped on October 1st. So this is going to be a problem for a lot of people, especially in light of the new memo from USCIS that says F1, status people, everyone's going to start accruing a lawful presence when their status ends and they didn't, change the status to another status. So this person, who left the U.S. and came back and has his H-1B approved, needs to then fly out of the U.S., probably before his status ends, and apply for an H-1B visa and use that visa to enter the United States to start the H-1B status. It means that this person cannot stay in the US and change his status. Now, there is a change of status application available if this person comes back, let's say in August, and within the month will get the H-1B approval, and before its status ends, file a change of status to H-1B. But that's not really an ideal situation because nowadays for a change of status between non-immigrant statuses, it would take 4 to 5 months. And before the change of status application is approved, the applicant cannot work. So there's going to be that big gap of time, and God knows what's going to happen between those gap of times, and the employer might decide to find someone else and lay this person off. So the quickest way is to go for what they call visa stamping. So again, if this person has a pending H-1B petition and is on OPT ends in August, travels out of the US in June, comes back in July, and H-1B is subsequently approved on September 29th, and that's the fact. This person should go for visa stamping and return to the US to resume H-1B petition status and cannot do a change of status in the United States because he had departed from the United States before the H-1B is approved. So that is the problem with traveling during OPT time or while H-1B is pending. So the first thing you need to do to figure out what your strategy is in a situation like this is to ask your employer if they filed it under consular processing or if they filed it under change of status. If they filed it under consular processing, then you need to know that if you're on OPT, you're benefited from cap gap provision, CAP, GAP, then you're able to stay in the US on OPT status until October 1st. But after that, you would be out of status because it's consular processing, not a change of status, so your status is not changed on October 1st. And therefore, you need to make arrangements to go outside of the US to do visa stamping. So you should probably start scheduling your appointments sometime in August or in July, depending on how busy the consulate is. And again, remember, consulates will schedule H-1B visa appointments 30 days before October 1st. So you could start early, and if premium processing comes back, then definitely use premium processing to get the petition approved, and then use the petition to obtain an H-1B visa to return to the United States. So that's really the only downside, to traveling during OPT, because you would lose that chance to change status. So if your employer filed your I-129 petition for H-1B under a change of status category, then that part of it is going to be denied due to your departure. So you would have to go for visa stamping if you were to travel while H-1b petition is pending. So that's the downside. But I would say don't let that stop your wedding. But if it's just a short trip abroad, try to avoid it until after your H-1b is approved. Then coordinate it with the time to get visa stamping so that you could shoot two birds with one stone and just go for stamping at the same time you're going for vacation or something along those lines. Plan your time well so that you don't have to fly back and forth and incurring lots of charges on airline tickets and things like that. But if you must, you can travel while your H-1b is pending, while you're on OPT, but just make sure you have an F1 visa and your I-20 is in line and you have offer letter, you have everything ready to go and ready to answer questions. We have not had any problems for clients coming back on OPT plus their F1 visa. So, admission generally isn't really a big concern. It's really the aftermath, visa stamping, that really is kind of a problem. Because a lot of countries, visa stamping is tough, like India. It's not so much tough as it is unpredictable. So you just have to be prepared to go through the rigmarole because a lot of employers, especially the IT consultants, consultancy firms, they are getting scrutinized at the U.S. Embassy in India. So yeah, it's important to just, be calm and take all your documents, apply for the visa, and if they put you in administrative processing, you just have to wait it out. So, I guess the best thing to do if you can is to avoid traveling, because if you change status with USCIS, then there really isn't any problem because your status would go from F1 to H-1b without needing any stamping, and it's much more predictable. Once H-1b is approved, your status should change if you have not violated your status in any way. This is where an interesting point might come up because we have that recent update on STEM OPT third-party placement rule change on the USCIS website. So for those of you who are working in client side who had their OPTs approved, either STEM or initial, when you apply for H-1b change of status, you might get an RFE asking you about the third-party placement because USCIS may start to adopt the position that working in third-party site means that you did not maintain your status. And again, if you did not maintain your status while H-1b is pending, you cannot change status and must go for visa stamping in the U.S. consulate. So we might start seeing that happening in the next few months. You never know, it might not happen because right now this whole thing about STEM OPT third-party placement site is so it's not explained. So no one really knows what's going on. Although we have seen RFEs on bona fide relationships, employment relationships for STEM OPT applicants who are working third-party sites. So we're beginning to see that, but that doesn't necessarily mean that USCIS will come down with a position that says, okay, everyone who works on third-party sites are going to be out of status on their OPT. I think that would be very draconian, like very serious. It would have serious consequences and far-reaching sort of problems for everyone who are on STEM. So I don't think that they're going to do that. But they might just, a few officers might just send RFEs out and say, tell us that you have, prove to us that you have maintained your status during OPT because we know that you're working on third-party sites and according to this new rule, working third-party sites means you did not maintain your OPT status. So we might start to see that, and we will come up with strategies to respond to that, of course, and probably lawsuits, here and there. I'm sure this issue will be litigated for quite some time to come. Well, thank you for listening to my rambling, and if you have any specific questions you'd like to ask, just reach out to me by email or any other way that's most convenient to you. Check out my YouTube website for contact information. I welcome questions and I answer them pretty quickly. So if you have any other questions or concerns, feel free to reach out. Have a good day, and thank you for tuning in.